So you file a patent application in the patent office, and a few years later you give them a call, and to your shock and dismay, your patent application has gone abandoned. Have you lost your right to protect your invention forever? Is it possible to revive your patent application if it's gone abandoned? And the answer to that question is yes, it is possible. Stay tuned to this video and I'll explain how. Hi, my name is John Farrell. I'm a Silicon Valley patent attorney. Welcome back to my channel. About 20 years ago, a friend of mine from Napa, California gave me a call and said, "John, my patent has gone abandoned. My patent attorney passed away a few years ago and forgot to pay the maintenance fee on the patent before he died. This patent is really important to me, John, because I'm trying to sell my company right now and it's the only patent my company has. Is there anything you can do to help me?" Well, it was a little more difficult in those days because since the patent had been abandoned for more than 2 years, we had to show that the abandonment of the patent was unavoidable. Now, in this case, we were able to do so because the death of the patent attorney caused an unavoidable delay in the payment of the maintenance fee. The maintenance fee record was held by the patent attorney, and only the patent attorney knew when the maintenance fee was due. And therefore, the patent commissioner accepted our petition to revive that dead patent and to restore the rights in that patent monopoly. Now, fortunately, in recent years, the patent law has changed, and now under Rule 137B of the Patent Code, we're able to revive an abandoned patent application or an abandoned patent by merely paying a fee, a petition fee, and by declaring that the abandonment of our patent application or our patent was unintentional. That is, we did not intend for it to go abandoned. Now, normally all we need to do is to declare that the entire period of abandonment was unintentional. No further explanation is normally required, although the patent commissioner can come back and ask for more facts if there's something fishy going on with the patent application. I've never had that happen, however, with any of my cases. Now, the fee to revive an abandoned patent application or an abandoned patent is kind of steep. It's $2,100 currently for a large entity, $1,050 if you're a small entity, and half that if you're a micro entity at $525. In addition to paying the petition fee, you need to pay all back fees that are owed to the patent office, any past maintenance fees that are due, as well as respond to any substantive office actions or submit any other responses that are due to the patent office in further prosecution of your application. Now, one of the things that often comes up with my clients is they say, "John, I can't afford to continue prosecuting the patent application. I'm just out of money. I don't have the money now to continue with this patent." Now, when this happens, I have to explain to them, this is an intentional abandonment. We're not going to be able to petition the patent office at a later time if you come into the money explaining that the abandonment was unintentional and I really would like to continue with the prosecution of this application. Not having the money is not sufficient reason for unintentional abandonment. Now, there's an issue that we need to talk about with respect to abandoned patents, and that's the issue of intervening rights. If a patent goes abandoned because of failure to pay a maintenance fee, the government takes the monopoly away, that exclusionary monopoly that you get with a patent, the monopoly of excluding others from making, using, or selling your invention for 20 years. The government removes that exclusionary monopoly. Now, if you come along later, let's say 2 years later, and you pay the back maintenance fees plus the petition fee, then the government restores that monopoly. But there's a period of 2 years in this case where there's no monopoly. It's a dead period for the patent where there is no monopoly. And we have to be careful because it's possible for another manufacturer or someone else to come in during that dead period and begin manufacturing your product or a product based on your patent. This manufacturer is said to have intervening rights. That is, he can continue manufacturing even if the patent is revived, any product that he began manufacturing, that he or she began manufacturing during this dead period. So we do need to be careful when our patent goes abandoned of these intervening rights that might exist with other companies. Okay, that's really all I have to say today about reviving the dead, about unintentional abandonment. If you have any questions or you have some comments about patents that you've had or patents that you've prosecuted, dead patents in your life, put them in the comments below. I'd love to read them and I'll try to respond to everybody who comments. Thanks so much for joining me on this video. I'll see you next time.